Well, good morning, everybody, and thank you so much for joining us today in achieving compliance with the new Respect at Work laws. Before we begin, I would like to acknowledge the traditional owners of the land on which I'm currently based, which is the Wurundjeri people of the Kulin Nation. And I'd like to take a moment to pay my respects to their elders past, present, and future, and acknowledge the rich culture and history that they have brought to this beautiful country. I'd like to start by means of a little bit of housekeeping. So I am, of course, thrilled to be joined today with the Australian Human Rights Commissions and representatives thereof, but I would like to remind you all that this seminar is intended only for educational purposes, and nothing we say today is intended as legal advice or specific guidance for your organisation. We would like to invite you to use the chat during today's session. And if you've got any questions, you are very free to ask those, but please ensure they are not questions that may relate to specific initiatives within your organisation or requesting advice or guidance from the Commission. As a regulator, they are not allowed to do that. I would like you to put any questions into the chat, and to the extent that others think that's a relevant question that they would like an answer to, please, if you could vote on the questions. If we get questions where there's a lot of interest, the Australian Human Rights Commission have been kind enough to say they will help us compile some responses to those questions to the extent that we don't cover those topics within the breadth of today's webinar. It is a lot of content that we're going to try and get through today. And I thank you all very much for attending and for your interest in this incredibly important topic. By way of introduction, I'm the CEO of Safetrac and thrilled to be joined with both Tanya Murphy and Ella Kucharova from the Australian Human Rights Commission. Tanya is the Director of Positive Duty, Compliance and the Enforcement Team. She specialises in compliance and enforcement regulatory operations and help facilitate the introduction of the Commission's new powers to regulate the positive duty obligations under the Sex Discrimination Act. And Ella is the Legal Director of the Positive Duty team and has worked in the legal team of the Australian Human Rights Commission for over 6 years and has played a pivotal role in drafting a lot of the recommendations and law we will be discussing today. So absolutely thrilled to be joined by these experts in this topic. You're going to hear it straight from the horse's mouth today. So thank you very much, both Tanya and Ella, for joining us today. Before we begin, I'd like to run a quick poll to better understand our audiences and their level of understanding of the laws. Just going to briefly start this poll. I just drag this here and I'm going to launch this and going to ask what department or role you currently have within your organisation. I'll let that run for a moment. We can see by looking at the responses that we're largely joined by talent and human resources, people and culture. And for a large part, we're seeing this is the department that has been deemed responsible for a lot of the compliance issues within their organisation. I'm going to go ahead and end that poll. And I'm going to share those results so you can all see those. And you can see that talent and culture making up 54% of our audience, followed by compliance and risk, 9%, learning and development, 7%, health and safety, 9%, and several owners, founders, only one board director, 4% C-suite. I'm going to go ahead and stop sharing that. And then I'm going to run a separate poll where I'd like to ask you, please. Sorry, I think I did share that. And I'm going to go ahead and launch the next poll, which I'd like to gather an understanding of how far progressed your company is in relation to the compliance with the Respect at Work laws. And by the way, there's no judgment here. Just because the Commission's here doesn't mean you can't be honest with where we're at. It is a journey, and we're aware that we're all on them. Hopefully, most of you have started that journey, but I'm noticing that not everybody has. And hopefully this session will be able to provide you some foundations for the start in your journey. I'm going to go ahead and just let that run for a minute longer. People have finished voting, so I'm going to end that poll and I'm going to go and share those results. And you can see that we've got around 9% that haven't yet commenced, 28% that are just starting, 35% somewhat progressed, 22%. Well done to you guys. Well on the way and advanced, always looking to improve. Obviously, we would like to see more people down towards the bottom two of these categories, but we will do our best to help you with the knowledge that you need for your organisation during today's session. So moving on from the polls, by way of background, the Australian Human Rights Commission, which I will, and we all will refer to as the AHRC, is an independent third party which investigates complaints about discrimination and human rights breaches. In December of 2023, it was enacted with new powers, which gave it the ability to inquire and ensure compliance with organisations' adherence to the Sex Discrimination Act. Since then, we've seen really large shifts in many organisations making huge efforts towards compliance with the body of legislation, but it's still fair to say that some people are still at the beginning of the journey, and there's a lot of uncertainty about what it is that they are expected to be doing. Tanya, I'd love to hand over to you, please, for an introduction to the Commission and its powers.
Thanks, Deb, and it's really lovely to be here talking to you today about positive duty. And I have to say that that poll was really good to see, and knowing that some of you are right at the commencement of this journey, that this introduction will be good for you to hear what the positive duty is. And for those of you who are further along, it's going to be a little bit of a refresh. But I also might just add that Ella, who is here with me today, was actually quite instrumental in the formulation of the positive duty guidelines. So we're very lucky, and we do have somewhat of an expert here for matters that relate to that. She's very humble, so I'm probably going to get in trouble for beefing her up later, but it's well deserved. As a bit of an introduction, I suppose the first question really is, what is the positive duty in the Sex Discrimination Act? And you'll hear me refer to that as the SDA. For obvious reasons, it's easier to say. So the SDA requires employers and persons conducting a business or undertaking, and you've probably heard them referred to as PCBUs, but they are required to take reasonable and proportionate measures to eliminate, as far as possible, 5 types of conduct, which we refer to as relevant unlawful conduct or the positive duty conduct. And they are discrimination on the ground of sex in a work context, sex discrimination, sexual harassment in connection with work, sex-based harassment in connection with work, conduct creating a workplace environment that is hostile on the ground of sex, and related acts of victimisation. Now, if you take one thing away from this webinar, and of course I'm hoping that you take more than that, but if it is just one thing, let it be this. If you are only considering the positive duty in relation to sexual harassment in your organisational business, then you are not going to be complying with the positive duty. There are the 4 other forms of conduct that I just mentioned that you also have a duty to eliminate as far as possible. And in particular, behaviour that can be broadly described as sexist, even if it's not sexual in nature. And I think a lot of us are probably more familiar with that unlawful conduct of sexual harassment. So you will need to make yourselves knowledgeable in relation to the other forms. just a bit of an FYI, you'll hear from us refer to employers and PCBUs as duty holders or organisations and businesses, but know that the term PCBU and workers have the same meaning in the SDA, the Sex Discrimination Act, as they do in the WHS Act or the Work Health and Safety Act. So for people familiar with these terms, they are consistent in meaning. Just in case you don't already know, and Deb did just touch on this, the Australian Human Rights Commission, which Ella and I usually refer to as the Commission, or you'll hear us just say we, it's a national independent statutory organisation. It's established by an Act of Federal Parliament, and our mission is to protect and promote human rights in Australia and internationally. And the Commission's functions relating to the positive duty in the SDA are performed by the President of the Commission or the President's delegates. And as the regulatory team, we sit under the Commission's General Counsel. And of course, we have the wonderful Anna Cody, who is our Sex Discrimination Commissioner, and she plays a separate but very important advocacy role in relation to the positive duty. The compliance and enforcement powers, as Deb was saying, they enlivened back in December 2023. However, the duty to comply with the positive duty actually came into effect 1 year earlier in December 2022, and that was to allow duty holders to sort of get across their obligations in this space. So when I say the Commission's powers have enlivened, it really means that the Commission can now commence an inquiry when we reasonably suspect that a duty holder isn't complying with the positive duty. And suspicion can come from different areas such as information or advice provided by other regulators, the media, government agencies, and also impacted individuals, particularly those that may complete our online form and provide us with information. And it can also come from unions and workers' representatives. So to ensure compliance with the positive duty, the Commission also has the power, and these are the new powers that we were talking about, to conduct these inquiries and to provide recommendations to achieve compliance. We can now issue compliance notices, and those notices can specify actions that a duty holder must take or that they must refrain from taking to address any non-compliance. And we can now also apply to the federal courts for an order to direct compliance with a compliance notice if it hasn't been followed. The other thing that we can do is also enter into enforceable undertakings with duty holders where they can agree to do or not do certain things. So the other thing to probably note is that the Commission can commence an inquiry without the consent of the duty holder, and we have powers to compel the production of information and documents, and we can also compel and examine witnesses. So I suppose I'm just going to finish this very brief introduction saying that the focus of the Commission at the moment is on workplaces with known significant drivers and risk factors for these relevant types of unlawful conduct, and where our engagement with those organisations and businesses will create opportunity for broad influence and to affect meaningful cultural change. But we'll have an opportunity to talk about this in a little bit more detail later. So I might hand back to you. Thanks, Deb.
Thanks, Tanya. And Ella, we're going to speak to some of those standards and guiding principles. Could I pass on to you to give us an overview of those?
Yeah, thanks, Deb. It's lovely to be here today. As you'll see from the next slide, we've got an infographic that sets out there are 4 guiding principles in our guidelines and 7 standards. These are the 7 standards that the Commission expects duty holders to meet to satisfy the positive duty. And here they are. As you can see, they address issues relating to leadership, culture, knowledge, risk management, support, reporting and response, and monitoring, evaluation, and transparency.
Thanks, Ella. When we look at that that circle of duties or things that organisations need to be doing, can you maybe take us through some of those in relation specifically to leaders and what they should be doing in order to be compliant in eliminating sexual harassment and other positive duty conduct occurring within their workplaces or businesses?
Yes, certainly. So we know that committed and effective leadership is critical to driving and sustaining meaningful cultural change within organisations, including in relation to positive duty conduct. So we went to a lot of trouble, including by way of that very circular graphic, to try and combat the idea of any kind of hierarchy within the standards. The Commission expects duty holders to meet all 7 standards. We know that they're all crucial to eliminating the unlawful conduct covered by the positive duty, as well as being interrelated. That being said, and knowing that, you know, human nature loves a hierarchy, a lot of consideration did go into deciding which standard should be number 1. And as you can see, leadership is our first standard. And this was on the very strong recommendation of our former Sex Discrimination Commissioner, Kate Jenkins, who, following the Respect at Work inquiry, firmly believes that leadership is integral to the success or otherwise of the project of eliminating sexual harassment and other forms of positive duty conduct from the workplace. And this was informed by concerns that she heard during the Respect at Work inquiry that sexual harassment, you know, has previously been considered to be a human resources or a people and culture problem and not an issue for leadership. But as we'll see, the leadership standard in the guidelines emphasises the importance of senior leadership, and senior leaders are expected to actively oversee the measures put in place to eliminate the positive duty conduct. So the guidelines define a senior leader as a person with responsibility for the management and governance of a business or an organisation. So in smaller organisations, this will usually be the business owner, and in larger organisations, it will usually include the board or equivalent, the CEO, the executive leadership team, partners.
Ella, we've certainly in our work have seen quite a lot of HR individuals saying to us, we know we need to be doing this, but we don't have the support or buy-in of our leaders. In your experience, are you seeing that leaders are taking this duty seriously? And do you think there's a lack of understanding of the positive duty, or what do you think that needs to be happening from a leadership perspective at the moment?
Yeah, it's a great question. I think following the Respect at Work report and the recent changes to the law, as well as just the constant media attention, I think it's clear that there is a strong expectation in the community that issues of work-related sexual harassment and other positive duty conduct will be taken seriously by organisations. And in our experience, this is being recognised and taken seriously by many senior leaders. During the consultation process for our guidelines, as well as more recently, we've experienced, you know, good faith engagement from employers, as well as, you know, their obvious desire to create safer and more respectful workplaces for their staff. We do have a new legal landscape, and the positive duty has certainly been helpful in understanding these issues through this additional compliance lens. We have been told that it's been effective in some cases in, you know, focusing the attention of boards and executive leadership teams. Although, of course, you know, as a relatively new endeavour, there's still a lot of education and learning that's needed. This was supported by some research that was recently conducted by the Australian Institute of Company Directors and the Australian Council of Superannuation Investors in partnership with the Commission. And it focused on sort of board directors' preparedness for the new positive duty. And that report found that 85% of ASX 300 directors that were surveyed believed that prevention of workplace sexual harassment and other positive duty conduct was a high priority issue for their boards. However, most of the directors that were surveyed, including 80% of women directors, didn't believe that their boards were fully equipped to meet their obligations. And sort of this suggests that these issues are being taken seriously by organisations and they are being prioritised, but there may be some gaps in how organisational systems and processes are aligned with the positive duty guidelines. That resource on board directors' preparedness, it includes a lot of really practical and useful questions for board directors to direct to their executive leadership teams. And I understand that we're going to link it in the chat here. So I'd certainly encourage people who are having some of those concerns with their boards or their senior leaders to sort of bring that to their attention.
Wonderful, thank you. I'm going to move to the next slide, which I've skipped over the poll because I did them both together. So what are the, Tanya, and I'll move on to you, what are the consequences and penalties, and are there workplaces, leaders who, what are the consequences for workplace leaders who neglect those duties in relation to these laws?
Yeah, thanks, Deb. Well, I think Ella's made it abundantly clear about the expectations of senior leaders. But from a regulatory perspective, if following an inquiry that we undertake, if the Commission finds that a duty holder isn't compliant, then we can make recommendations for preventing a repetition or continuation of that non-compliance. And we spoke about this briefly at the introduction. And we can also issue compliance notices specifying the actions that must be taken to address the non-compliance. If we do issue a compliance notice, the notice will specify a reasonable period, which won't be less than 21 days, for the duty holder to comply with the directions in the compliance notice. And at the end of that period, we'll assess whether those directions have actually been complied with within the specified timeframe. The compliance notice can also direct that the duty holder provide evidence of compliance with the notice. So if a duty holder hasn't complied within the time frame, then the Commission can actually apply to the federal courts for a court order to direct compliance. And if the court is satisfied that the compliance notice has not been complied with, then the court itself can make an order directing that the duty holder comply with the notice. But most interestingly is that they can make any other order that the court considers appropriate. Another point I might add here is that of vicarious liability. And again, this links back to what Ella was talking about when it comes to senior leaders and board directors. And vicarious liability is a legal principle that holds employers responsible for the wrongful actions of their employees. So this means that if an employee commits an act that is unlawful under the Sex Discrimination Act, while acting within the course and scope of their duties, the employer can be held liable unless they took all reasonable steps to prevent it. So duty holders can take steps to prevent vicarious liability by following the Commission's guidelines and implementing policies and procedures to eliminate that relevant unlawful conduct. Thanks, Deb. Oh, I think Deb's might be frozen.
Yes, you're right there, Tanya. What I might do is I might take back the host responsibilities and I'll get this to the slide. Just give me one moment. Sorry, everyone.
I can probably, I think I've got the next question here, if you would like me to read that out.
Yeah, amazing. That would be question 5.
Yeah.
Yep.
So this again is for me, so it makes it easy. And the question here is, what are the Australian Human Rights Commission's current priorities when monitoring and inquiring into duty holders' compliance with the laws? And this really is a great question. And I think if you want a really in-depth understanding of our approach, you can look at our compliance and enforcement policy on our website. And I think I provided a copy of the link that we might be able to put into the chat. And if you haven't been to our website more recently, you will notice that we've had a bit of a major upgrade. So we've now got areas that will make it quite easy for you to navigate to and find the information that you're after. So I highly recommend that you go in and have a look at that. The other thing as well is we do regularly update our website, so it's worthwhile checking back from time to time with new information and materials that we're providing to assist duty holders and also workers in this space. Look, it's probably easiest today to start with the Commission's functions so you can understand what we are actually here to do. So the Commission has compliance and enforcement functions, which are our new functions, and they inquire into and ensure compliance with the positive duty. And we also have specific statutory functions to promote understanding, acceptance, and public discussion of the positive duty, and also to undertake educational programs and research into the positive duty. So today's participation in this webinar is actually promoting understanding and acceptance of the positive duty, which is one of our statutory functions. So understanding our functions, hopefully you can see that the Commission's role really is focused on promotion, research, education, leading practice, and encouraging proactive and voluntary compliance, whilst also obviously remembering that we now have our suite of compliance and enforcement powers that we can use if required. So when we're determining which duty holders we're actually going to engage with, the approach that we're going to take, again, it's outlined in our compliance and enforcement policy, but it is a risk-based, intelligence-led and data-driven approach. And we'll be focusing our resources on workplaces to effect that meaningful cultural change. And you'll hear this phrase a lot, meaningful cultural change. And it really means that we're seeking to facilitate a fundamental shift in societal beliefs, values, norms, and practices that leads to lasting positive impacts for workers and workplaces when it comes to eliminating relevant unlawful conduct. And as I mentioned earlier, we will be focusing on workplaces with those known significant drivers and risk factors where engagement will create opportunity for that broad influence and, again, affecting meaningful cultural change. So thanks for that. Are you back with us, Deb?
I am. Sorry, I lost internet, so I've changed hosts, so sorry for that. Moving on to you, Ella, we've certainly seen some confusion out there in relation to the intersection of the various bodies of legislation and how these new laws intersect with WH laws in particular, in terms of preventing sexual harassment and responding to sexual harassment claims. Could you maybe give us a little bit of an overview of that intersection?
Yeah, certainly. So alongside the positive duty in the Sex Discrimination Act, there are also positive duties in work health and safety law. So if we're looking at the Federal Work Health and Safety Act, a PCBU, so that same term, must ensure that so far as is reasonably practicable, workers and other people are not exposed to risks to their psychological or physical health and safety, including risks from psychosocial hazards such as sexual harassment. So we now have these separate duties, one under WHS law and the other under the Sex Discrimination Act. And to the extent that they address the same conduct, so as you mentioned, in relation to work-related sexual harassment, for example, duty holders must comply with both sets of laws. Now, there are some commonalities in the laws. So sort of generally speaking, they both require PCBUs to do what is reasonable in the circumstances to eliminate specific harmful conduct relating to work, for example, sexual harassment. And in practice, the actions that a duty holder will take to comply with their WHS obligations will also assist them in complying with the positive duty under the Sex Discrimination Act and vice versa. But it is also important to note that these are separate duties and they're sourced in laws that have different foundations and different focuses. So, you know, the Sex Discrimination Act, it's a human rights law. It's got a foundation in equality rights, and it gives effect to Australia's international treaty obligations under CEDAW, which is the Convention on the Elimination of All Forms of Discrimination Against Women. And so this focus on equality harms means that the positive duty in the Sex Discrimination Act, it extends beyond conduct that may pose a specific or identifiable threat to health and safety. So, for example, it covers indirect sex discrimination, which is when a condition, requirement, or practice may appear to treat everyone equally, but disadvantages people of a particular sex if it's not reasonable in the circumstances. So the duties have different scopes, although there is overlapping conduct. And I would say, as you've identified, work-related sexual harassment is probably the most notable. The positive duty guidelines set out what the Commission expects organisations and businesses to do to satisfy the positive duty in the Sex Discrimination Act. And as I said, those actions are similar to the ones that duty holders are required to take to comply with WHS laws. There was a lot of consideration that went into making those schemes as consistent as possible, as well as the preventative action, the same type of preventative action, for example, you know, a robust risk management framework for addressing sexual harassment that can be used as evidence of compliance with the multiple legal duties. But at the end of the day, duty holders will need to satisfy themselves that they're complying with both WHS laws and the Sex Discrimination Act.
So effectively, an organisation would be wanting to run some type of a risk matrix across each of those laws, and some of the controls for the risks under those may be the same, but some may be different. So there may be some controls in place that are applicable to both, but it wouldn't be fair to say if you're compliant with one, you're going to be compliant with the other.
Yes, that's right.
Yeah, great. Thank you. Tanya, moving on to the next question, are there any specific guidelines or resources available to help duty holders understand and fulfil their WHS obligations in relation to these laws?
Yeah, look, as Ella was just saying, compliance with the positive duty under the Sex Discrimination Act won't necessarily ensure that a duty holder is compliant with their WHS obligations. And I think you summarised that really, really well, Deb. The Commission isn't a WHS regulator, so we don't provide advice in relation to WHS issues. So again, we strongly recommend that any duty holder seeking advice on WHS issues, they contact their relevant WHS regulator in their state or territory. Having said that, there is information out there to help duty holders and workers understand how the different jurisdictions operate when it comes to this intersecting space between sex discrimination legislation, WHS legislation, and also industrial relations legislation. And in fact, some of the WHS regulators provide information for referral pathways for this type of unlawful conduct in the workplace. And I know that if you type in Comcare positive duty and do a search in the search engine, it will take you to a one-page document, which should assist you to further understand the differences between those jurisdictions. And you can also do the same for Safe Work New South Wales. And it will take you to a document titled, I think it's Respect at Work, Positive Duties Explained. And I know Queensland has recently put out one similar. In fact, if it's not already out, it must be very, very shortly coming. I saw it come through my email the other day and it looked fantastic. The Safe Work New South Wales document compares specifically the positive duty regulated by Safe Work New South Wales with the positive duty regulated by the Commission. And because the WHS laws have been harmonised throughout Australia, obviously with Victoria being the exception to the rule, these documents are another resource that you can use. And as I was saying earlier, we have recently made some changes to our own website, and we are looking at producing a similar tool that we will add to our website where people can go along and view those differences as well. So we'll try to collate that information to make it easy. Safe Work Australia and WHS regulators have also produced their own detailed guidance about what people must do to satisfy their own WHS duties in relation to psychosocial hazards, including sexual harassment. And in the guidelines, our own guidelines, we strongly recommend that organisations and businesses separately consult that specific guidance. So again, exactly what you were saying, Deb, when you summarised Ella's response so eloquently, it really needs to be done. There will be parallels, but there may still be gaps.
Yeah, I've got to say we've been enormously impressed with the documentation and the information sharing that's come from the Commission. And I think you may have noted it's always being updated. So it's a great resource for everybody out there to really get to the bottom of what they need to be doing with very useful guides. And it really does take users on a step-by-step journey and worth checking in all the time for the changes and updates that are constantly happening. Moving on to potentially the next slide, I'd like to maybe ask if you've got any examples of the collaborative approach, and you've already given, a couple of how the regulators are going to work together for comprehensive enforcement. Is this something that they would work together on? If an organisation breached something, would they work together, or would it be separate underneath these different regulations?
Thanks, Deb. That's a great question. Look, I don't think there's a never say never. And I think that when we approach these sorts of matters that as they arise, it really needs to be on a case-by-case basis. We do have our own independent legislation, and as we've just touched on, they are different. However, we have been collaborating with the other regulators to communicate information and to assist duty holders and workers understand this intersecting space, which we've just sort of spoken about. And an example of that can be seen, as I said, on the Safe Work New South Wales, the Comcare, and soon, hopefully, if it's not up already, the Queensland websites. So we are sharing information to look at making that burden reduced as much as possible for duty holders. And the Commission's also attended a number of presentations with other regulators to sort of get this message out. And at the moment, we're currently organising a regulator roundtable to further look at opportunities at how we can assist each other and communicate effectively between the different jurisdictions. So this really will be a bit of an ongoing venture that I imagine will become more streamlined and sophisticated as our own practices mature. But at the moment, our focus has been more on enhancing communication pathways to avoid unnecessary duplication or unintentional crossover. And we expect to work together to amplify messaging in this space.
Terrific, thank you. Ella, I'll move on to a question that is near and dear to my heart, which is training. And we're certainly aware, and I'm sure everyone is out there, that there's just a plethora of choices of training, of online, of face-to-face, of all different ways of implementing training programs, but also a myriad of topics on which to train, whether it be in sexual harassment, whether it's discrimination, diversity, inclusion. There's a very large range of topics, and I think there's some confusion out there. We've certainly spoken to people who think if they roll out a sexual harassment training course, they would be compliant with the legislation. So I'm really interested in the advice and guidance from the Commission in this particular area.
Yeah, certainly, Deb. Look, we know that effective education has a critical role to play in eliminating positive duty conduct from workplaces, no matter the size of the organisation. It's very difficult to eliminate something if you don't know what it is, or if your workers don't know what it is. But as we saw before, education is just one of those 7 standards, and just focusing on the education standard will, leave duty holders, I think, quite at risk of being non-compliant with the duty as a whole. But with regards to that knowledge standard, it's standard 3 in the guidelines. And the first aspect of the knowledge standard is about having a policy that relates to respectful behaviour and positive duty conduct. So we anticipate that many organisations will still need to update their policies to cover the changes in the law, including the full scope of the positive duty conduct that's covered, as well as the expectations around core policy content, which are set out in our guidelines. And policies are, of course, an important way of educating workers on their rights and responsibilities, as well as being somewhere that an organisation can commit to creating and supporting safe and respectful workplaces. And the second aspect of the knowledge standard relates to supporting workers through education, in particular on expected standards of behaviour, so including actions and attitudes that foster equality and respect. We know that focusing on the positive types of environments that people want to create, that they want to work in, can be more effective than just focusing on what they can't do or what is unlawful. But of course, people also need to understand how to identify the relevant unlawful conduct and the consequences for engaging in such conduct as at work, as well as their rights and responsibilities in relation to safe, respectful and inclusive workplaces, which includes their role in preventing and responding to relevant unlawful conduct. So the guidelines say that to be effective, education really needs to be presented as a necessary and meaningful part of participating in a workplace, and not just simply, as a ticker box compliance requirement. And I think Tanya will speak a little bit more about what our resources have to say regarding effective education.
Thanks very much, Ella. Tanya, moving on to you. Frequency of training is often a topic that comes up. Training is not a one and done activity in this type of area. It is something that we recommend is ongoing and repeated, perhaps even changed from time to time, updated alongside organisation policy, legislative change. These sort of things are very important that we continue to refresh training on a regular basis. Could you maybe talk to this topic for us and how sort of frequent this training should be, and what type of topics and areas the training should be covered in order for you to be seeing this as a compliant and worthwhile training program?
Yeah, thanks, Deb. And again, you summed it up quite well. So, look, I just want to reiterate what Ella was saying earlier, that it really is important that you don't look at training as the thing that's going to get you compliant. It's one of the 7 standards. Again, as Ella was saying, standard 3 of the guidelines is the knowledge standard. And the guidelines recognise, just as you were saying, Deb, that those traditional approaches to training and education, for example, a one-off training session at induction, the set and forget, has proven to be ineffective at eliminating this type of relevant unlawful conduct. So the focus of education shouldn't be solely on the frequency of formal training or learning, but on its quality, its accessibility and effectiveness, including consistent and regular messaging from leaders. So you can see that circular approach that Ella spoke about before really does link in together, and these standards do interact. The Commission has published a fact sheet called Effective Education and Training, and that is free and it's available on our website again. And this identifies that education and training activities are most effective when they are accessible, inclusive, relevant, regular and ongoing, as well as being person-centred and trauma-informed. So again, of course, and I think you touched on this as well, Deb, we need to make sure that the training, the relevant part of that is that we are keeping abreast of leading practice and we're updating that training as we deliver it.
Fantastic. A question that we've had a lot of lately is in relation to who actually participates in that training. So on to the next question relates to leaders and the requirement to actually train leaders. We see an awful lot of organisations roll out training to their staff and maybe to their managers, but board directors are often exempt from training, which is interesting given they're responsible for the duty within their workplaces. So perhaps could you maybe talk to us about this topic and whether the guidelines require leaders to be trained in these very important topics?
Yeah, thanks, Deb. Well, if we go back to the leadership standard that we looked at earlier, you'll remember that there are specific expectations that relate to the senior leaders of an organisation, which does include the board. This includes that they understand their obligations under the Sex Discrimination Act, and they have up-to-date knowledge about positive duty conduct. So there are, of course, lots of different ways that leaders can be educated on their obligations and on positive duty conduct, but we do expect that they understand their responsibilities here, and that's been clearly set out in the guidelines.
Thank you. I'm going to move on to a poll now, and we're going to look at what your biggest challenge is in relation to implementing respect at work initiatives. I've certainly noted a couple that we've seen here and that we've witnessed through Safetrac and discussions that we've had. But I'm really interested in the audience and what challenges that they're currently having. So we've got several choices here: understanding the legal requirements, training staff effectively, creating a supportive workplace culture, tracking and reporting compliance, or anything else. And there is quite a long list. We probably just didn't have time to list them all. So I'll let that poll run for a moment. And when we've got a good amount of people that have submitted that poll, we'll publish those results. We can see that we've got understanding of the legal requirements is the top item. And again, I refer you to the beautiful website, which very, very clearly sets out the obligations, training staff effectively. And I think this is, as we've said, there's no one solution here. It's different training for different people, for different groups, for different responsibilities. It's complex to do this very well. Creating a supportive workplace culture is an ongoing issue that absolutely must stem from leadership. We've got tracking, reporting and compliance. Tracking and the traceability of it is a big ongoing issue, and other issues. So it looks like we've hit on the main issues here that people are experiencing, and good for us all to see that these are the issues that people are experiencing at the moment. Did you have anything that you wanted to comment on, Tanya or Ella, in relation to any of those findings?
Just that it is a very complex legal landscape, and it's certainly something we've heard before. We've done our best, obviously, to try and simplify it, and would certainly suggest not even just our guidelines. We have a resource for small business, and that is obviously the audience there is small business owners, but that's our simplest explanation, and it sets out a number of questions that we encourage small business owners to ask themselves. And I actually think it's a very good introduction for anyone who might be finding it all a bit complicated, because we recognise that there are complexities here, and that's where we've tried to simplify it as much as we can. And I think the questions are really good prompts for people to sort of assess their own organisation's compliance, whatever the size. So I do encourage people, regardless of the size of the organisation, if they're feeling a bit overwhelmed, to start with the small business resource.
Yeah, fantastic. One of my other favourite resources that you produced is the Leaders Framework. I think that really sets out very clearly the type of things that leaders need to be following and implementing in their organisations. I think it's a really clear and succinct guide. I think it's an excellent resource. Moving on to the next question, comes to resources and what type or amount of resources organisations should be spending in relation to their duty holders, and what are they expected to do in order to comply with these set of laws?
Well, thanks, Deb. In this respect, we've got some legislation that we can actually refer back to, which makes it actually quite clear. So the positive duty legislation under the SDA provides the answers, and the wording of the legislation is strong in that duty holders are required to eliminate this conduct as far as possible by taking reasonable and proportionate measures, which we'll talk about in a moment. We consider that this is actually a fairly high test, and we know that not all organisations or businesses are the same, and we understand that what's reasonable and proportionate will be different from one organisation to the next. So we can't really say what is going to be reasonable and proportionate for you or for your business or organisation, but we can again refer back to the legislation to give us a little bit of guidance here. So when we're looking at this, the Commission and the courts are going to consider there's 4 things: the size, nature and circumstances of the organisation and business, their resources, financial or otherwise, the practicability and the cost of the measures to eliminate the conduct, and any other relevant matter. So again, there is no one-size-fits-all approach, and duty holders will need to take into account these considerations when asking themselves if they've done everything reasonable and proportionate to eliminate the unlawful conduct, bearing in mind that the courts and the Commission will be asking the same question. So you want to really have that at the front of your mind when you're thinking about implementing those 7 standards that are outlined in the guidelines. Just one other thing I might add as well, when we were talking about resources that are available, we've mentioned the guidance, our guidelines. That's excellent, and it has tables in there that give specific actions and also documents for each of those 7 standards. The information guide that we put out gives you a lot more information if you're not really sure what those different types of relevant unlawful conduct are. The information guide is a really good guide to look at in that capacity. And we also have posters you can put up and things like that, which are all free to download as well.
Fantastic. Thank you, Tanya. Ella, when we talk about compliance, we often talk about carrot and stick. There's obviously liabilities and penalties for organisations who aren't compliant, but then there's also carrot, as in there's benefits of being compliant. And I think this area of law is one that there's massive carrot involved in the benefits of being compliant with these guidelines. Could I maybe get you to speak to the incentives and benefits that organisations are seeing as a result of adhering to the guidelines?
Yeah, thanks, Deb. Look, as the Human Rights Commission, we obviously take a human rights-based approach to these issues. So our focus is very much on promoting and ensuring equality and dignity and inclusion. But there is, as you say, of course, also a business case for creating safe and respectful workplaces. The research shows that in organisations where workplaces are unsafe or have high rates of sexual harassment and other positive duty conduct, there's decreased productivity, there's increased employee absenteeism, there are issues retaining staff, there's a real risk to the reputation of the organisation, which also might impact on its ability to attract the best people or attract investment, increased insurance premiums, increased legal costs, so on, so on. The proactive focus of the positive duty really does aim to create these safer workplaces where sexual harassment and other positive duty conduct doesn't have the opportunity to thrive. And this accompanying shift, ideally in workplace culture, can mitigate these risks, such as productivity loss. And it can also uplift a company's social license to operate, as well as, increase productivity, creativity, innovation. I think it's also really important to emphasise that when duty holders don't seek to eliminate the conduct, there can often be a very real human cost we know that there's often very significant impacts on people who experience or witness these harmful behaviours. And this can be physical, can be psychosocial, it can be health harms, it can be impacts to a person's employment or their long-term career prospects, financial impacts that come from lost income or opportunities. So really there are lots of very positive reasons to be creating safe and respectful workplaces.
We're certainly seeing a lot of large organisations focus on ESG measures in their organisation, and we're certainly seeing this area of law fit very firmly under the S in the ESG. So in their focus, we are seeing organisations derive significant benefits with a long-term shareholder value being the focus of ESG measures. So it fits very, very firmly into the benefits achieved through tight ESG measures. So just onto a poll in relation to the main prohibitions you're facing in terms of being compliant with the laws. If I could ask you all to just move to that question. And I think we'll host the poll. I can get you all to respond to that. You'll see that the prohibitions that we've placed here are budget, lack of awareness, fear of outcomes, support from directors and C-suite, so obviously a lack of support, time, a lack of internal resources, or competing priorities. These are all the things that we've been hearing. There may be others, but I'll ask you to just take a moment to respond to that, and then we'll share those results. Okay, if we can go ahead and share those results. I'm conscious that we are nearing the end of the hour. We'll see that the largest prohibition that we're seeing there is time, lack of internal resources, competing priorities, lack of awareness, and time are the big ones here. So lots of issues for reasons for non-compliance, which hopefully this session can help with at least some of those. In moving on to the next slide, what mechanisms should duty holders be placing to ensure the effectiveness of their efforts in preventing and addressing sexual harassment and other forms of positive duty conduct in the workplace?
Yeah, this really relates to Standard 7, monitoring, evaluation and transparency. So I'll be very quick. It's a fairly complicated standard, so I would encourage you to look at it in full. But as a starting point, it will usually assist duty holders to develop a prevention and response plan. So this is a document that obviously sets out the organisation's strategy to eliminate the positive duty conduct. It also provides something tangible that an organisation can consult with workers on. And then duty holders should regularly review the effectiveness of the prevention and response plan by considering relevant data. What is relevant data will change based on different business contexts, but it could include things like reviews, audits and surveys, trying to understand the issues, if there are any gaps, what works, what doesn't work, and how to make adjustments to be more effective. So consultation with the workforce is a very critical element of measuring effectiveness of strategies and sort of reflecting workers' voices. And it's one of the guiding principles that we have in the positive duty guidelines.
Thank you, Ella. And I think our last question will go to Tanya in relation to surveying and benchmarking. We've heard a lot of resistance and fear of surveying and benchmarking for fear that, I guess, delivering those surveys and benchmarks will either A, uncover conduct that organisations don't want to know about, and or information that may lead the Commission, in the event of an audit, to see that they had issues and provide a framework for what they were. I know the Commission does recommend strongly benchmarking of staff on a whole range of issues, not just on the prevalence of sexual harassment, but on conduct and culture that could lead to that sort of behaviour. Could you maybe, Tanya, help ease some, I guess, concerns in this area and speak to what the Commission is looking for in this area and the positivity of actually conducting benchmarks and surveys?
Yes, certainly. And I'll try to get through this fairly quickly, so I'll speak a bit faster. But look, I think one of the first steps to eliminating relevant unlawful conduct is understanding the extent of the issue within your organisational business. And if there is sexual harassment or other relevant unlawful conduct occurring, then the issue is that it exists and that it hasn't been eliminated. So conducting internal surveys is one way duty holders can seek to gain visibility over culture, and it also goes to meeting a number of outcomes under our other standards. So we're really aware of prevalence data relating to work-related sexual harassment and the other forms of relevant unlawful conduct, and it's actually really common. And the 2022 National Survey reported that fewer than 1 in 5 Australian workers formally even reported sexual harassment when they experienced it. And 22% of those who did make reports were unsatisfied with the process once the report was made. So if a duty holder hasn't received any reports from its workers, this doesn't necessarily mean that there isn't relevant unlawful conduct occurring, particularly if no efforts are made to understand the workplace culture and experiences of workers. Instead, it's actually likely to be suggestive of the possibility of an unsafe reporting culture. So we actually expect to see an increase in reports as workplace culture improves and workers feel safe to raise concerns. And it would probably raise more questions with us if a larger organisation claimed to have no reports of sexual harassment or other types of relevant unlawful conduct, and that there hadn't been any recent efforts to undertake a survey of the workforce. So the relevant standard is the guidelines, is standard 6, reporting and response, and it's really possible that without undertaking an internal survey, duty holders, particularly larger organisations, won't be aware of the extent of underreporting or barriers to reporting. And that's really important to developing effective reporting and response processes. If through our engagement we see that duty holders are not yet compliant, but they are actively taking steps towards achieving compliance and they have a roadmap, it's less likely that we would need to increase our regulatory response with use of coercive powers, remembering that we have discretion to engage with duty holders who are acting in good faith to improve their own processes and address non-compliance.
Fantastic. That's wonderful clarity. Thank you, Tanya. We're heading to the conclusion of this webinar, but I've got one more poll for you, which is, do you feel confident about the next steps your organisations need to take in order to be compliant with the Respect at Work laws? We've only got 3 options here, so this one should be a quick one. Yes, we have a clear plan. I've got somewhat, but we need more guidance, or no, we are unsure about what to do next. So let's hopefully hope that this seminar has provided people with somewhat of a plan or some guidance, or at least resources where they can go to know where to go next. So I'm going to leave this one moment to run. I will note that there have been a number of questions in the Q&A. I'm not going to have time to address any of them now, but to the extent that some of them were popular questions and not after distinct advice, we will look to respond to you after this webinar. So we've got 30% of people saying they've got a clear plan. So fantastic, that's great. And we've got 62%, which is somewhat, but we need more guidance, and 8% with no, we are unsure about what to do next. Ella or Tanya, do you have any advice or discussion points in relation to these responses?
I think it's understandable and it's in line with what we've been hearing. I think in terms of, a structured response, would just, encourage people to look to the guidelines, to look to the simple formulations of the resources that have been put out there, like the small business resource. It's quite structured, the framework. You can move through it. There's lots of different practical example options under each of the standards. So, you know, it's interesting because the Commission is both the regulator, but it's also subject to the positive duty. So some of the work that we've been doing is working within our own organisation to be compliant. And that's certainly what I've been recommending to our senior leadership, to go through the guidelines, to look at all the examples, to think about the ones that resonate most with our workforce, and, you know, put into place strategies to get us there. And, you know, that's something that we were doing towards before the law came into effect. But yeah, there are lots of examples. We certainly don't say businesses need to do all of them, but for people who are putting in place as many as possible, they're going to be in a very good position to be compliant. It's quite a structured way where you can just look through the various example options and say, okay, well, is this something that we can be doing? And if not, why not? And, you know, there are those assessments based on the particular size and circumstances of the business. But I think just working through the example options methodically is a very good way. And it's certainly one that we found to be very helpful.
Thank you so much. Tanya, did you have anything you wanted to finish off with?
Yeah, probably just adding on to what Ella was saying, we also have on our website e-learns that people can use. So that may also be beneficial as well. And also, if the organisation or business is in the fortunate position that you have the finance and the backing, you can also look to seek outside your organisation to areas that do offer expertise to assist you.
Thank you so much. Both Ella and Tanya, thank you so much for your time, your wisdom and your guidance that you've shared with us today. Appreciate the generosity of the Commission in helping educate and guide organisations in the compliance with these laws. Just as a final step, I will say that we have recorded this webinar, and for attendees, we will be distributing a copy of that recording. So for people who are asking for notes or so forth, there will be a full recording that is sent to all attendees. So you are free to distribute that around in order to help educate the persons in your organisation that you think will benefit from that. So with that, I will say thank you very much, Ella. Thank you very much, Tanya. Very much appreciate your time. And thank you to all of those attending today. Appreciate you joining us and your interest and concern with these very important laws that we've recently implemented. So thank you.
Thank you.
Thank you.